Hi everybody and welcome back. Today we're going to be talking about the evolution of law. Now, uh, the basic idea of this lecture is we're going to start from the beginning of laws and human history and kind of catch us up all the way to today. So, with that in mind, where do laws come from? Laws may find their base in norms and customs, and typically they do, in fact, right? A norm is kind of a standard or a model of behavior, right? So, for example, it is a norm in a classroom for the teacher to stand in the front of the classroom and the students to sit out in desks, right? Um, and that's just kind of the standard of the model of all classrooms. And so if you were to create a new school, you would probably design classrooms in that way because of the norms of what education is. There's also customs, and customs are usual practices, habits, or traditions that are kind of informing laws as well, right? These might be religious traditions, they might be certain usual practices that for example, seatbelts, right? It was when seatbelts were first introduced, it was not so customary to actually wear a seatbelt. Right now, I imagine the vast majority of you get in a car and buckle a seatbelt without even thinking about it, right? And so laws can come from both of these different places, either in norms or rooted in customs. Now, in primitive legal systems, law was really built around emphasis on these norms, customs, and religion. Typically, in these primitive legal systems, the laws were found in hunting and gathering, as well as simple agrarian societies. And we can even see those today in these basic kind of systems in like third world countries, for example. Emphasis was on clan and extended families, right? So we all, it was kind of all for one and one for all kind of mentality with our clan or our extended family. Laws weren't written or codified because in a large part there was no need to actually have them written or codified. And there were no developed real political systems. The leaders are either kin leaders, or there was a council of elders, or like a tribal chief, or maybe even a religious leader that was the person in charge. Courts may be assembled, but only temporarily to kind of solve conflicts when they needed to be. And you'll notice a big theme in this lecture is going to be the need issue, right? Laws are only formed when they are needed, right? Systems are only formed out of necessity. Now, in these primitive legal systems, there were no individual possessions, right? Emphasis, again, was on the common good, like I mentioned on the last slide. Feuds were between individuals, not between an individual and the state. And that's actually very different than the way our society is now, right? If you get arrested for a crime right now, it will be state versus Josh Behl, or the United States of America versus Josh Behl for federal crimes. Back then, it wasn't. If I got beat up by my brother, it would be Brian versus Josh. There was some distinction between substantive and procedural laws, but not necessarily a lot, and not nearly as many as there are today. Substantive laws, just as a reminder from intro, are these kind of rights, duties, and prohibitions concerning what is right, wrong, permissible, or impermissible, right? So do not murder, do not rape, do not steal. These are kind of substantive laws. Procedural laws, on the other hand, are rules regarding how substantive law is to be administered, enforced, changed, and used in the mediation of disputes. And so some rules, the procedural rules may be things like, you have to be served a prosecutorial information or get indicted by a grand jury. We can't interrogate you without reading Miranda rights. Those are kind of procedural laws as opposed to substantive. As primitive legal societies, those started to become more advanced, hunting and gathering societies started to become more advanced, and cities started forming. The law, out of necessity, had to evolve. And that brought us to transitional legal systems. Typically, these are found in advanced agrarian societies and earlier industrialized societies. So why did they change? Why did we go from these primitive legal societies to these transitional ones? Well, the first reason is there were some integration problems. Different groups all came together and they were educated differently. They had different forms of currency. They had different political ideologies. They had different values and beliefs. And so we needed to try and figure out and identify some change that would make kind of everyone happy, right? We talked about consensus versus conflict paradigms. In transitional legal societies, it was really more of a consensus paradigm where it's like, let's look between what commonalities do we have between all these different groups and try and figure out what laws we should make about that. As these transitional legal systems developed, also, we started to see these clearer distinctions between substantive and procedural laws. Not only did we see the difference between substantive and procedural laws, though, but we also saw a distinction between private and public law, right? So public law are things like the structures of the government, duties and powers of officials, and the relationship between the individual and the state, and these things kind of affect society as a whole, right? And so the source of the feud evolved from a feud between individuals to a feud between an individual and the state as far as public issues, right? And so if someone in my family got murdered, it wasn't a crime against the person who got killed. It wasn't even a crime against my family anymore. It became a crime against the state because the state, everyone in society, right, who makes up the quote-unquote state, is affected by that murder. We cannot have a good, functioning, normal society if there are homicides taking place all the time, right? And so that's why it became a feud between the individual and the state, not a feud between two individuals. Private law also is more distinct, and this regulates the relations among non-political units, affects just an individual, family, or a unit. So, for example, a divorce is not an issue that is public, right? It does not affect society as a whole in the strictest sense. It affects the family unit. So a divorce would be private. If I had a personal injury claim, let's say I got in a car accident, it's not in the interest of society that I get awarded money for the neck pain that I now have. It's between me and the individual who caused that neck pain. Now, as you're hearing about this public versus private law and stuff, hopefully something is coming to mind, right? Hopefully this is, right? Criminal law or public law, and then civil law, which is more private law. And this distinction eventually came from that public versus private law. And so criminal law denotes wrongs against the state, the community, and the public, like murder, rape, and assault, whereas civil law pertains to private wrongs of parties against each other rather than against the state, right? Like mentioned, small claims or divorce. Now, obviously, with these distinctions in law, there was a new need for a bunch of other distinctions that needed to be present, right? So there was increased differentiation of laws reflected in increased complexities of the courts, right? Because we now had a criminal system and a civil system. The court system became much more complex. As societies got bigger, they weren't temporary courts, but actual physical buildings that people showed up to for the court, right? And roles in the court also emerged. We started to have judges, representatives and lawyers, litigants, court officials, jurors, right? Written records even of court proceedings became common because we might need to look back at those written records for issues that arise in the future. And so with this evolution, legislative structures also had to emerge because there were these courts that had emerged that said, well, here's what happens if someone doesn't follow the rules. And someone said, well, which rules do we have to follow and which ones don't we? Johnny is this religion, Jimmy's that religion, their religions don't agree, whose rules do they have to follow? Well, the legislature becomes developed then and emerges for that purpose. Now, that catches us up with this, as transitional legal systems become increasingly more complex, that catches up to modern legal systems of today. All the structures of a transitional system are present with the added idea that courts have an important role in mediating and mitigating conflict. In our society today, no one questions the authority of the court. The legislature has all these opinions on the law, the president has all these opinions on the law, but ultimately it's what the court says that's the final say, right? The roles of lawyers and judges have become highly professionalized, and in fact, there's no question about that. Getting into law school is extremely difficult, and on top of that, it's only a very small percent of lawyers that will even end up judges. And so these positions are highly professionalized. Appellate procedures have also been developed. We don't like what a lower court said, so we're going to try again. Policing has also developed. There's differentiated levels of policing. We have federal, state, and local laws and rules, and so we have federal, state, and local law enforcement. Legislation also changes have become more comprehensive, right? When we pass legislation, even at a city or state level, it is still a very complex and comprehensive thing that gets passed. And so in these modern legal systems, we see that everything has become significantly more complex as society itself has become more complex, right? The needs of society caused these legal systems to become increasingly more complex. Now, one of the keys to the development of the law from primitive to modern is the relation of the individual to the state. And this is super important, right? In these primitive legal systems, the people were the state, right? The individual was a member of the society, and so the individual could petition about what laws should be enforced and shouldn't and everything else. We kind of have the ability to do that now, but not really. In fact, Llewellyn contends that more primitive societies felt one with the law, and that in modern societies we feel outside of the law. And so that begs a lot of some interesting questions, right? Like, is the law actually made for us, or is it made in opposition to us? And depending on your political ideologies, your religious ideologies, your moral ideologies, a lot of people could make an argument for either one, right? But the fact of the matter is that these primitive legal societies felt like they understood the law, they were one with the law, and knew why they had to follow the law. Whereas in modern societies, a lot of people scratch their heads saying, why is that illegal? Or why do I have to do that? Or why is that the law? This evolution of law not only meant from one with the state, but it was to one before the state, as if the state was deciding what rights you had and didn't have. The state is granting privilege to you or not. And that can be a bit worrisome for some people. Now, in these evolutions of law, major legal systems have developed. Some such systems include, again, the civil law, right? And now this civil law is different than civil law as far as divorces or adoptions. This is a major legal system, not a subfield of law, criminal versus civil. This is civil law versus common law. Civil law is derived from Roman law, and the basic source of law in a civil law system is organized under codes rather than case-by-case basis found in judicial decisions, right? And so if it's not written down and codified in civil law, it doesn't matter much, right? And so the code is this body of laws. This is the most commonly used system in Europe, and legislation is seen as the primary source of law. And so in civil law systems, the legislature passing laws and telling people what laws are and aren't to be followed and enforced is kind of the last say. Now contrast that with the common law system, which is what we have in America, and we see that the basic source of common law is judicial decisions rather than codes, with judges seeking in each new case to adapt the principles worked out in previous cases to new facts and circumstances in such a way to achieve justice. So in a civil law system, the legislature passes a law, and that is that. In a common law system, the legislature can pass laws all day long. If judges say, no, I don't think so, those laws don't go into effect, right? Or they can go into effect until they get appealed to judges. The basic source of law in English-speaking nations is common law. So you'll see common law in Britain and America a lot. The emphasis here is on judges, which is also why people were freaking out this last election about Supreme Court picks, because who judges or which judges get picked could potentially have a huge impact on how the laws are applied and enforced. Now, there are obviously some major differences between the two, right? There are clear differences in the methodological approach to law. Both systems approach law very differently, one from the statutes and one from judicial opinions and precedent. There's also the development of judges. In civil law, judges are trained separately from lawyers because they have a very different role than lawyers do. Whereas in common law, judges are actually just accomplished and reputable lawyers that they want to pour over this past law to develop new laws or further laws, right? Also, the reliance on precedent is super important in common law systems, and in civil law, it doesn't matter. The way a lot of attorneys argue cases in today's society is by looking at all these past cases and making an argument saying, based on all these other cases, the answer to this case is very clear. In civil law, it doesn't matter what those past cases said. It's what does the law say. Now, this is the evolution of law and these major legal systems of law. We're going to switch gears a little bit and talk about the function of law, because not only is it important to see how law evolved, but how is law functioning and how do we view law in its function. First of all, a lot of people argue that the purpose of law is just social control. There are many methods of social control, right? There's a lot of different ways we could do stuff. Law is just that formal means of it. And so there's formal social control, like explicit rules of conduct. There's planned use of sanctions to support the rules. If you don't sign up for Obamacare, you will get fined if you don't have insurance. There's designated officials to interpret and enforce the rules and often make them, right? We have lawyers, legislatures, police that all help just enforce the rules. And so there's this very formal social control that's present. Legal institutions are responsible for creating and maintaining the rules and norms that define what is viewed as deviant behavior. And if you think about this just in general, right, and we'll talk about this as a theoretical approach later on in the semester, but even just looking at this, if you think about the fact that there are these explicit rules of conduct and that the most important people in America's society are judges, judges are former attorneys, attorneys have to go to law school, suddenly who is and isn't getting accepted to law school can have a tremendous impact on the outcome of law in America. And again, that's just kind of a little teaser for future lectures, but that's actually a very interesting idea, right, and a potential way that social control is present. Now, there are some other functions of law, for example, to settle disputes. And this is, there are alternatives to other means of dispute resolution, but the law offers a formal means of this dispute resolution, right, or dispute settlement. If, let's say, I built a fence on my neighbor's yard, my neighbor could come to me and say, hey, listen, you built the fence on my yard, move it over a foot. And I could say, oh my gosh, I'm so sorry, you're right, I'll go ahead and move it over a foot. And we can have a gentleman's agreement, shake hands, and be done with it. The law, that's a very informal way of settling disputes, though, right? The law offers a formal means of dispute to where I could say to my neighbor, no, it's not on your yard, this is actually my yard, and then we could sue each other in court and have a court decide who's actually right and have a court settle the dispute for us. Law also functions as social change. So the law functions as a mechanism for social change such that it is an institutionalization of a norm for behavior, right? We might all view smoking cigarettes as unhealthy for you. Currently, the law doesn't. If Congress wanted to, they could outlaw smoking cigarettes, right? And that would be this institutionalization of a norm for behavior. Same thing with seatbelts. It's also an internalization of the behaviors that reflect new values, right? So even as much as when Barack Obama and Hillary Clinton ran against each other for the Democratic nomination, they ran on a platform of marriage being between one man and one woman, right? And that's it. Gay marriage should not be allowed. Within really pretty short order, either they were lying to us the first time, or their opinions changed, or the public told them their opinions should change pretty drastically, right? And so we see this new value in a very, very short time that is functioning to where now gay marriage is legal in all 50 states. We see that the law is functioning in that social change, right, in that social order. Now, there are also some dysfunctions in the law, right? We've talked about the evolution of laws, the functions of laws, but the law isn't always perfect. So is the legal system used to maintain and enforce current patterns of wealth and status? Some people argue yes. In fact, Max Weber defined law as a coercive order, an order that has the potential backing of the full force of the state. And so ideally, each citizen is actually equal before the law. And if you read the law in its black and white letters, that is what the law says. The question is that actually true? Are individuals actually equal before the law? Does wealth matter? Does race matter? Do any other issues matter in determining the outcome of a legal issue? And if so, is that a dysfunction in the law? Probably. Donald Black considers law as governmental social control that makes use of legislation, litigation, and adjudication. Societies and organizations may have more law or less law, right? So, for example, I went to the University of Florida, go Gators, and we had a police force on campus, right? It's similar to Flagler security, except for they carried guns and had, a small holding cell and, were actually police. On college campuses, there were a lot of different laws that were different than off of college campuses. For example, it didn't matter how old you were not technically allowed to have alcohol in a dorm room. And so you could be 21 years old living in a dorm room on UF's campus, and you could get in trouble criminally for having alcohol on campus. Whereas if you were the same person, but you just lived, half a mile away off of campus, you wouldn't get in trouble for that. And so the University of Florida campus actually has more law than the broader Gainesville society because of the addition of those rules. With these societies and organizations having more or less law, is that a dysfunction in the law? Should the law be consistent across places? Again, some people would argue yes. Also, Black argues that certain kinds of discrimination are inherent in the law itself, right? Rules in principle may actually apply to everyone, right? In theory, all rules apply to everyone. However, legal authorities fall unevenly across social place, right? So social status greatly affects the use and application of the law. If you think about it, right, I imagine there's a lot more police policing West King Street than over on Anastasia Island. Now, some would argue, well, yeah, that's because there's a lot more crime on West King Street than there is on Anastasia Island, which is true. If you pull up the crime statistics, that's very, very true. But that means that the people on Anastasia Island have a lot more leeway if they're going to commit a minor crime, because the police probably won't be around to find it, than if they're commit that same crime on West King Street. Not only that, but there's this beautiful quote by Donald Black here that I just love, and if I could have it framed, I would. I just don't think my wife would let me hang it in the house. Because legislation can have highly stratified effects, right? The quote by Donald Black says this: "The law in its majestic equality forbids the rich and the poor from sleeping under bridges, begging in the streets, and stealing bread." Now, when you initially read that, you say, yeah, that's not stratification. Of course it does, right? It doesn't matter who you are. You could be Donald Trump. You're not allowed to sleep under a bridge. You could be Steve Jobs. You're not allowed to beg in the streets, right? What's interesting about it, though, is if you're Donald Trump, do you ever have a need to sleep under a bridge? Some of you probably hope you would, but do you have a need to sleep under a bridge? No, you have a house. Do you have a need to beg in the streets? No, not if you're Steve Jobs. You've got money, right? And who steals bread? People steal bread that are starving. People that are wealthy don't need to not steal bread because don't need to steal bread because they're not starving to death, right? And so while all of these laws on their face we might agree with, they have these stratified effects because they actually are things that wealthy people or even middle class people wouldn't do anyway. Only the poorest people in society would do. What's also interesting is some of these also, right? It's illegal to beg in the streets. If someone's starving to death and you're walking down St. George Street downtown and they come up to you and ask for money, you could have them arrested for that, right? It's interesting, though, that if you walk into Publix and there's little girls in green uniforms, they can beg you to buy cookies. Around Christmas time, there's some guy dressed up like an old man ringing a bell. He's allowed to ask you for money. But if you're homeless and do it, because you actually need food to survive, suddenly it becomes illegal. And so we need to start asking ourselves, why is it that we've outlawed some of these behaviors? A lot of people in classes past will say, well, we don't like people sleeping under bridges because it drives property values down. We don't like people begging in the streets because it makes people uncomfortable. And maybe it's dangerous. There could be a degree of danger. We don't really hear too terribly often about homeless people beating up other people, but maybe there's a danger issue, right? But let's stop and think about that. We don't like people sleeping under bridges because it drives property value down, which means that the value of my property is highly more important than whether or not someone has shelter from the weather. It makes me uncomfortable when someone comes up to me on the street and asks me for money. My discomfort is significantly more important than that person actually eating their next meal. Now, granted, I'm not trying to sit up here on a moral high horse by any stretch of the imagination, because I get uncomfortable when people ask me for money in the streets. I don't particularly like driving by bridges and seeing people sleeping under them, especially if I live near there, right? But we've outlawed things that really are something that people in society don't want to have to deal with or see. Because if we see it, it might make us feel bad about our position. So let's just throw them out to the fringes, right? Some other dysfunctions in our law is that the law tends to have conservative tendencies. And by conservative tendencies, I in no way mean politically conservative tendencies. I mean that it's slow to change. It has a tendency toward being immovable. It's very hard to change things, right? So by establishing a social policy of a particular time and place, or by making the precedents of the past binding, the law exhibits this tendency toward resistance to change, right? Are our morals and our beliefs about life the same as they were 70 or 80 years ago? Of course not, right? Back then, if you listened to the rock and roll, you were going to be doing drugs and having all sorts of illicit sex, and it was going to be really naughty, right? And now those same people that were like, yeah, I'm going to stick it to the man with my rock and roll, are the same ones complaining about rap and pop music, right? And so there's these kind of conservative tendencies. There's also a rigidity in the formal structure of the law, right? Once a law is in place, continuous revision and disruption is avoided in the interest of predictability and continuity. Yeah, it's a bad law. We don't like the law. We know the law doesn't work. But we don't really want to go through a lot of trouble to change it because we need it to be there for a while at least, right? And that's kind of some of the dysfunction of the law. Now, that's all we are going to really talk about this lecture, but I hope this lecture made you think and made you start questioning things. And really think about some examples in our laws where this rigidity is there. Think about some examples in this law of our laws where there might be some stratification. What are some other types of laws that maybe disproportionately favor wealthy people versus unwealthy people, or vice versa? Maybe white people over minorities, or vice versa, right? There are a lot of ways that we have these laws and systems set up that we don't question, but once you start fleshing out some of these ideas and start questioning them, you start realizing, wow, our law really is not perfect. There are really some dysfunctions here. So thank you all so much, and I will talk to you all soon.